I'm a mess right now. I just roll out of bed for this. All right, so Sarah Boone, her trial's going to happen in less than a month on October 7th. And there's been some new motions that have been filed. So let's look over those motions that's been filed. Sarah Boone actually has, I think, 3 attorneys representing her right now. There is the one attorney that picked up her case. There's a co-defendant. Sorry, not co-defendant. There is a co-counsel. And then I don't know if there was another co-counsel that was, because I saw another piece of paper that had 3 attorneys on there that was representing Sarah Boone. So I was like, oh, did she pick up another co-counsel? I mean, Mr. Owens did say that, you know, he needs all the help that he can get. Let's cover Sarah Boone, y'all. All right, so Sarah Boone, her defense, they're going to take on the battered spouse defense. And the last time I made a video about this, the state was like, no, she can't do that. She said, 1, it was an accident. So why is she taking the battered spouse defense when she said it was an accident? She didn't mean to do it. Didn't mean to leave George in the suitcase. Forgot about him. Woke up the next morning and found that he was in there unconscious. And not only that, I think the state said that, like, well, if you're going to rely on this expert to say that she has battered spouse syndrome, well, we can't just rely on the expert because everything that the expert heard is all hearsay from Sarah Boone, blah, blah, blah. So we have the defense. They replied to the state, and they're actually going to have a hearing in 2 days on Thursday at the 19th. So definitely be here to cover that hearing. But let me drag all this stuff over here. Give me a second. Oh, wait a second. Do we not get an IMS report for Sarah Boone? Did the judge stop doing that? Maybe. Because now that she's not doing pro se anymore, maybe they don't need to give the judge the IMS report because maybe she doesn't need to get the laptop and all that stuff since she has representation now. Sarah should have gone to advertising, picking up attorneys with the ad. She should have thought about doing this. She should have thought about this before planning to unalive someone. Criminals aren't smart. They think they are. You know, Charlie thought he was smart. Donna thought they were smart. Speaking in code terms, speaking in TV languages. They thought they were smart, but no. It's hard. It's tough. Okay, so state's motion to strike the defendants. Okay, this one I will refer back to in a second. Notice of hearing. So on September 19th, 2024, 2 days from now, they'll have a hearing at 1:30 p.m. All right. Defense response. The state's motion to strike defendant's notice of intent to rely on the defense of a battered spouse syndrome. That is very wordy. Whew. Comes now to the defendant by and through the undersigned attorney and files the defendant's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome and alleges as follow. 1. Defendant's notice is legally sufficient. Battered spouse syndrome is synonymous with battered women syndrome, which is recognized as a subcategory of post-traumatic stress syndrome by the DSM-5. The rules require the defendant to give notice of the intent to rely on defense no later than 30 days before trial. And that's what they did. Number 2, at the hearing before this honorable court, wherein the defense... Oh, should I zoom this up a little bit? I don't know if anyone likes to read with me, but there you go. Sorry about that. It's actually better for my eyes, too, to zoom it up. I don't know why I did it. Number 2, at a hearing before this honorable court wherein the defense sought a continuance, expressly noting the recent efforts to identify, vet, and pursue expert testimony on behalf of the defendant, Assistant State Attorney Dave Cacciatore Jr. expressly advised the court before any specific affirmative defense had been raised that not only would the state not be prejudiced by the assertion of battered women syndrome, that it was already prepared for the possibility of the said defense and had an expert witness that intended to rely upon to counter any possible assertion of the battered woman syndrome. As a result of this position, the state objected to the defense's notice to continue the case. Number 3, the notice of intent to rely on battered spouse syndrome was timely filed by the defense on September 6th. The notice of intent recognized Dr. Julie Harper. So again, Dr. Julie Harper was the expert that Padilla was planning on using. That was attorney number 2 of Sarah Boone, where they were about to go to trial. I think Dr. Julie Harper met up with Sarah Boone about 6 times during that time. And then it seems like they weren't going to use her because of all the different attorneys they went through. But now Mr. James Owens was like, you know what? Let's use Dr. Julie Harper. Already met with Sarah Boone 6 times already. Sure, it'll be fine. So the notice of intent recognized Dr. Julie Harper as his expert as required by the rule. Dr. Harper's address was also provided as necessary. Other witnesses and their addresses have not been identified. However, the violent nature of the relationship between the defendant, Sarah Boone, and the alleged victim, George Torres, was raised by the defendant as early as interrogation conducted by the homicide detectives the day following Torres' death, as she repeatedly asked the detectives to return her phone to demonstrate prior episodes of violence against her by Mr. Torres. Now, remember, that was when she was doing her interrogation, and she's like, yeah, he's done this to me. Just look at my phone. He's done that to me. You'll see it on my phone. You have my phone, right? Just look at my phone. You'll see all the stuff on there. Numerous documents and records produced by the state in the instant matter supported the possibility, if not the likelihood, the defendant having suffered from battered women syndrome. To the extent the rule recognizes the possible limitations on the defendant's ability to identify all witnesses, addresses, specific nature of their testimony in support of the defense. The defense has complied, and the particulars of those supporting events have been apparent to the state, law enforcement, any entity that has investigated in the matter. I need a drink. Oh no, did I run out of water? I ran out of water. Number 4, it is apparent that not only was the state on notice, in quotation marks, of the likely reliance on the battered women syndrome, it was prepared to respond and is neither surprised nor prejudiced by the defendant's notice of intent to rely on battered women syndrome defense. Number 5, further, defendant's notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in Rule 3.201, given the circumstances of the case. They're going to talk about the rules, contemplates a situation to which the defense is unable to provide a detailed statement of particulars to the notice of intent to rely on the defense of battered spouse syndrome. B, provides the pertinent part. The notice shall contain the statement of particulars showing the nature of the defense the defendant expects to prove, and then names and address of the witness by whom the defendant expects to show battered spouse syndrome insofar as possible. Because initially when the defense filed this, they only provided the name of Dr. Julie Harper. Now, we see the defense, what they did was they actually amended their original notice of intent. Now it has more information because the state objected to the original one, and then the defense was like, oh, okay, well, let me provide more information then. I got you, state. The undersigned is unaware of any Florida cases applying this language to a specific case. However, a plain reading of the rule implies that the court has the discretion to determine that the defense did not have sufficient time to provide a statement of particulars. Here, as previously noted, counsel for the defendant had insufficient time to uncover the full nature of the defense, the names, the addresses of all the witnesses expected to testify. Thus, the defendant's notice of intent to rely on the defense of battered spouse syndrome complied with the notice required found under Rule 3.201B, given the circumstances. So again, given the circumstance, because he just jumped on the case and he didn't have time to get all the witness and all the information yet. And when he comes back with the amended one, he'll have all that on there. Let's see. The state's reliance on Medina and Hickson is misplaced. The state's reliance on Medina and Hickson to preclude a reference to the battered spouse syndrome and Dr. Julie Harper's testimony is premature. In Medina, the defendant sought to introduce expert testimony during the trial regarding battered spouse syndrome without predicating it on facts already in the evidence. In Medina v. State, the court affirmed the trial court's decision to exclude the proffered expert testimony because the expert relied on inadmissible hearsay evidence. In this case, the state is attempting to use Medina to strike and limit reference to battered spouse syndrome in a pre-trial motion. However, the defendant had not had the opportunity to lay the foundation for Dr. Julie Harper to testify, mainly because the trial began October 7, 2024. So they're like, well, the trial hasn't started yet. You guys haven't given a chance for us to lay the foundation. So wait until the trial. Therefore, at this stage of the proceeding, Medina and Hickson do not preclude reference to battered spouse syndrome and Dr. Julie Harper's testimony. Number 7, the state is improperly extending the reasoning in Medina and Hickson to rule on 3.201. Medina did not hold that insufficient notice under 3.201 precludes the defendant from utilizing or referencing the state. The court in Medina does not cite Rule 3.201 or state whether the defendant sufficiently listed a statement of particulars. The court only considers the defendant's failure to present evidence of abuse before the expert's testimony. Number 8. Furthermore, the state's position mistakenly assumes that Rule 3.201 statement of particulars must list witnesses expected to testify to the battered spouse syndrome defense at trial. As noted earlier, Rule 3.201 gives the court discretion to determine what is legally sufficient notice given the circumstances. Specifically, Rule 3.201 states the defendant must list the witnesses expected to testify insofar as possible. The state's view of Medina and Hickson would preclude a defendant from presenting the battered spouse syndrome defense and underline when it is impossible to provide a list of witnesses expected to testify to the defense. We're almost done. Number 9, therefore, Medina and Hickson do not preclude the defendant from representing battered spouse syndrome in her opening statement, nor does it preclude Dr. Julie Harper from testifying prior to the defendant testifying. Number 10, lastly, it should also be noted the defense has moved from a statement of particulars regarding the state's theory of prosecution to which the state has objected. All right, so this is their defense amended notice of intent, where they're going to provide more information. Amended notice of intent to rely on the defense of battered spouse syndrome. All right, procedural posture. Number 1, August 30th, 2024, a notice of appearance was filed in the above styled cause. Number 2, September 5th, expert Dr. Julie Harper met with the defendant at Orange County Jail. Okay, that was a couple weeks ago. On September 6th, 2024, the notice of intent to rely on defense of battered spouse syndrome was timely filed. Number 4, the time defense provided the nature of defense and the witness insofar as possible in bold. Number 5, to date, additional information has been obtained through discovery and investigation efforts. Number 6, accordingly, the defense moves to amend. Ew, I saw strawberry vodka. Oh, sorry. I thought I saw strawberry vodka. I was like, that sounds disgusting. All right, back to this. Accordingly, the defense moved to amend the initial notice to proffer the additional information. Number 2, nature of defense. Battered Women Syndrome, BWS, has been described in a condition wherein a woman who has had a long-standing personal relationship with a man in which she is frequently subjected to physical abuse remains with the man, but eventually acts against him because of her fear that his continued abuse will mortally injure her. Yeah, we'll see how the defense lays this out for us, but right now I just don't see how I can twist my mind, bend my thoughts in order to see where we can get with that being a defense for Sarah Boone. Number 8, at the time of the alleged offense, the defendant was suffering from battered spouse syndrome as a result of physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres. Number 9, in support thereof, the defense will present witness testimonial evidence, records, and pictures and video evidence support its contention. So that's why Sarah Boone really wanted to get to her cell phone, because she has recordings or pictures of her being bruised up and videos and stuff like that. Now, I wonder if there is, I don't know. I don't know if men will document their bruises or injuries. In most cases, I feel like usually it's women, but maybe George documented his injuries as well. Or maybe his family members did. Maybe his family members were like, oh, hey, what happened to you? Why do you have a bruise here? Here, let me take a picture of it. Let me take a video of it. Or maybe when there's like family get-togethers, maybe there are some pictures or videos of, Sarah Boone, George being bruised up. But I do wonder if there's anything on George's phone that would show that, maybe the abuse was also both ways, because maybe George also had bruises and stuff like that as well. I think there were witnesses that did say that they both beat each other up. Sarah Boone beating on George beating on Sarah Boone. They both had bruises. Although Sarah Boone seems to have been closer with the property manager, and I think the property manager really sympathized for Sarah Boone. Number 10, in particular, the evidence will demonstrate factors that trigger BWS, the physical symptoms experienced during BWS, to the extent behavioral and psychological symptoms exhibited by the defendant that are consistent with the person who suffers from BWS, and the impact of BWS as it relates to the facts of this case. Expert testimony. So it seems like to me they weren't able to get the other expert testimony that they really wanted. There was another expert that testified in I think it was called the Marsh Thompson case, where she was acquitted of murdering her boyfriend by shooting him in the back a couple times. I think he was shot 9 times and then 6 of it was in the back or something. That one seems kind of interesting. I kind of want to look into that case. Number 11, Dr. Julie Harper, forensic psychologist, will be a Category 8 witness for the defense in establishing this condition on behalf of the defendant. Number 12, to date, Dr. Harper has met with and evaluated the defendant on multiple occasions. The visits date back as early as August 2020. Wait a second. So that means that if they have Dr. Julie Harper who, evaluated Sarah Boone, did the state already have their own expert to evaluate Sarah Boone? Or did they recently put in a motion to have an expert to evaluate Sarah Boone? That way they can kind of rebut Dr. Harper. Was that what it was? I think the state said they wanted to have their own expert to evaluate Sarah Boone. Because, we can't just go off of Dr. Julie Harper's words. We got to make sure we have another expert on the other side to evaluate Sarah Boone as well. Witnesses. The witnesses relevant to BWS defense include Dr. Julie Harper, Officer John Alden. I'm assuming this officer probably responded to a separate incident where he was responding to a time where maybe maybe it was when George was arrested, because there were times where I think there was a time where George was arrested and there's a time where Sarah Boone was arrested. So we have Officer John Alden, Officer Kenneth Davis, Officer Joseph O'Neill, Officer Patrick Strawn. I'm assuming these are officers that responded when George was arrested. And then we got F, Mr. Brian Boone. Yes, I do agree with that. You can be a perpetrator and a victim. Yep. Mr. Brian Boone. That's Sarah Boone's ex-husband. So I wonder where he stands with this whole thing. I kind of feel bad for Brian Boone because Brian Boone, you know, his picture has been used in like thumbnails, you know. I don't think Mr. Brian Boone was be involved in any of this mess with his ex-wife that he supported for years because she was just a drunk and wouldn't get a job. Oh boy. So Brian Boone, you know, is going to testify. And I do wonder what he's going to say. But Brian Boone also has custody of Sarah Boone and Brian Boone's child as well, which I think by now should be maybe. I think her kid, was he 8 or 12 at the time that Sarah Boone was arrested? I'm assuming maybe they're like in high school now. Number 14. Defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses for photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. The evidence will be disclosed as it is discovered. All right, well, we'll see what happens. You know, maybe when the defense put on their side of the story, maybe people will see things differently. Maybe. I think that was about it. I was trying to see if there's any IMS report with Sarah Boone, but I'm assuming since she's not pro se anymore, maybe the judge doesn't need the IMS report to know what happens with her while she's in the jailhouse. And then there was a document that, listen to his interview. I wouldn't use in defense of San Lucas was, 9. Okay, 9. Laura, you know, went over Brian Boone police interview. It was more unfavorable, really, than favorable. Oh, I haven't seen it yet. Okay, so maybe we'll watch that. How long is the interview with Brian Boone? Do you guys know? So for Thursday, here are the motions that they are going to address. Motion for the statement of particulars. The state said they don't want to do that. Motion for additional discovery. I forgot where the state stood on that. Second motion for additional discovery. Motion to appoint forensic psychologist. Motion to appoint forensic psychologist. I think they have to get JAC's, since Dr. Julie Harper already met with Sarah Boone, I wonder if that means JAC already approved it. Motion to appoint, crime scene reconstruction death investigator. That's what they definitely need to get JAC on. I'm assuming JAC has to be approved for approving these two. Motion for the return of the property. Is that for the cell phone, maybe? Response to state's motion to strike defendant's notice of intent to rely on defense of battered spouse syndrome and amended notice of intent to rely on defendant's defense of battered spouse syndrome. Okay, so these are all the motions that they're going to cover on Thursday. Police cam. Oh, yeah, the police cams. Okay, okay. Brian Boone police body cam and audio only interviews. Brian said she used to beat him. Yeah, I remember hearing that. Brian said that after, I think something happened to Sarah Boone when she got pregnant and she just really, really wasn't the same anymore. Like she just would just get drunk all the time, be drinking, going to bars, not really working, not doing anything. Okay, I mean, if it's that, then yeah, that sounds really rough. Let's do this. I want to rewatch the body cam footage. I want to rewatch the Sarah Boone interrogation. And then we'll listen to Brian Boone's. Yeah, Dreading, they post a lot of interrogation stuff on there. The audios, the interviews are what I listen to. Okay, if you guys are in my Discord, can you guys post the links in my Discord? That way I can make sure that we listen to all the correct interrogation, stuff like that. We have a true crime channel in the Discord. Just post a link on there to make sure we're all good. And then I think we'll do that because we have so much free time now. No Donna Adelson. But like I said, I'm going to go to Hawaii for a wedding. And I think now that there's no trial, we could probably extend the trip out a little bit more. Her husband said that she would hit him and claw at him and stuff on body cam. Pretty sure the police reports of the batters have noted that George had injuries as well. Does Sarah not know what Brian told the police? I mean, honestly, Sarah Boone had what? How long was she going pro se for? How long did she have her laptop for? How long did she have the digital evidence for? I'm sure she rewatched the body cam footage and she knows exactly what Brian Boone said about her. I mean, honestly, you know, I don't know. We'll see. We'll see what happens. We'll see. Maybe Brian Boone will give us more information. But from what I remember from the body cam, a lot of the stuff that he knew between Sarah Boone and George, it was mostly from what Sarah told him. I don't think he ever said anything about him actually witnessing anything. But like I said, maybe it was in the body cam. But it's been a while since I watched the body cam stuff. David Edwards, Sarah Boone had videos and depositions. If Sarah's defense brings in George's brother's criminal past, I don't think they're going to do that. There's no point in doing that. Are you talking about the murder that happened this year? Because I don't think that's pertinent to the case at all. The prosecutor is free to bring in Sarah Boone's brother being a registered sex offender. Oh, I haven't looked into that, but I did hear about that quite a few times. Chat bringing it up.